Okay, so hopefully the jury can see the monitor that's in front of him. That'll assist you, especially.
I would like to welcome now our guest to help break all this down. In studio, criminal defense attorney Jessica Ledingham and remotely civil rights trial attorney Joe Richardson. Jessica, Joe, thank you so much for joining. I think that's all my alliteration for the time being. But let me ask you first, Jessica, and that is why sometimes the reality is you have a witness going out of order. So we know the state is still presenting its case in chief, but out of order, the defense is calling this video expert.
Because it's all about authentication. Like, is there something wrong with the video, right? The video expert is trying to, the defense wants to plant doubt in the seeds of the jurors' minds and say, before you see this and you take this as truth, let me give you this video expert.
Right, and so, and I know the only reason typically is because of logistics, that sometimes the witness has to be called out of order. Joe, what do you think we might hear from this witness? We know there's been testimony of the video shown to the jurors. Hard to see, quite frankly, and some of them were too hard to see and graphic for us to really show our viewers, but that neighbors' houses have allegedly of the incident. And I'm going to tell you this, it was hard to see some of it, but boy, the gunshots, the hearing of the gunshots were jarring no matter what a video expert says, Joe.
Sure, and I would imagine that because this is the defense's video expert, it will either be definitive towards the defendant because of what it does show or because of what it doesn't, right? If you can't be sure, it's really dark. How do you really know what actually happened? The defendant says he was swung on, etc. If you can't make out anything that people are doing with their arms during that time, then there would be a suggestion there that, for instance, oh, it's not clear that he wasn't swung on because of what, you know, of how dark it is and, you know, those types of things.
And so let me stay with you, Joe, and ask you this. I think this is a case where often in self-defense cases, we see the defendant having to testify. But in this one, especially, given everything you just said, I think Jordan Palmer is going to have to take the stand. What are your thoughts?
Probably so, and the fact of the matter is dead men tell no tales, right? And so the victim here is not going to be able to testify, and this is a situation where it's just the two of them and no one else, and no other witnesses to refute what the defendant would say. There, of course, is going to be the matter of cross-examination and whether or not they can pull in, the prosecution can pull in other evidence that might trip him up. But this would seem to be the kind of case where he would testify, particularly because there's no one physically there to refute his testimony.
Yeah, I agree with you, Joe. I think that's absolutely true. Jessica, I want to go back just a little bit of something that happened before this witness, and that is there were 3 jurors seen crying in a hallway. They were spoken to by the court, by attorneys, and there was a motion for a mistrial by the defense saying it's cumulative. These things are happening. Apparently there were family members in the gallery with T-shirts, stickers, or if not in the gallery, by their cars. I wasn't sure which, but that some of the jurors were not comfortable in the parking lot because of it. All of this cumulative, the defense argues, the prosecution says there's absolutely no evidence that these jurors cannot continue to hear the evidence and deliberate. Ultimately, the judge ruled before this witness, I do not find sufficient grounds for a mistrial. What are your thoughts? Are you surprised? You were watching, you were on with Julia Janae. What do you think of the judge's decision?
I absolutely disagree with the judge's decision. And I think an appellate court will agree with me and disagree with the judge. I think it was way risky that he did not strike it down and say, okay, you're right, this is a mistrial, because the jurors felt intimidated. That's horrible. The jurors should never be intimidated by anyone. And how are they supposed to be not biased and not prejudicial when they feel intimidated and they're crying and they're in the parking lot and they don't even want to be in the same parking lot? The judge made an error in not granting the mistrial here.
I was a little surprised, and the judge did say the defendant can always raise that issue again and move for a mistrial again. I was a little surprised, but the judge made the decision. They're proceeding with the trial. Okay, coming up next, we're going to hear from that defense expert in the return mail murder trial. Plus, next hour, the Tennessee Bureau of Investigation and the Attorney General's office will hold a news conference to provide information about the ongoing search for the most wanted fugitive Austin Robert Drummond. Stay tuned for more.